All right, welcome back to the House Judiciary Committee. We're looking at H606 as it is on the floor of the Senate, and we'll see if it gets changed on the Senate floor or not. But and we'll go to Carolyn Hanson next. So there have been a lot of questions and issues that have come up in the test.
Well, I think I've written them down, but ask away because I'm really just here to answer you all's questions. My name is Carolyn Hanson. I'm with the Attorney General's office. And I just want to start out by framing this, and I think everybody's aware of this, but this issue that we're looking at with people who have an ERPO against them or someone who has a relief from abuse order against them, it is perhaps one of the most dangerous times that exists for the petitioners, because when a person is first told that they have to relinquish their firearm and they are in possession of guns, which first of all, that's a lethality factor right there. It's one of the top 3 lethality factors. And then the third thing is that this time of being, separated and having a court order, that's a step towards taking control away from that person. And so it's a very dangerous time. It's very important that we follow through with these orders and make sure that when somebody takes a step like this to come and ask the court to provide an order that the person relinquish their firearms, that happens. And it's one of these things that sometimes people just think it's automatic. They think, well, we spent a lot of time on talking about when we ought to have orders like this. And so we just assume that it happens once it's ordered. And the big point of this work group, and what I want to make sure you all take away, is that it's not happening. So there are orders issued, and Vermont currently has no system. It doesn't necessarily even require legislation to have a system, but we have no system. And because this is a hot button issue for folks, I'm not going to play that down. We did come first to ask that you appoint a legislative study committee to look at this. And so we put together the work group that you've heard a lot about today. And those were all stakeholders that you all chose as important to have in the room. People who understood this process and played some sort of role in this process. And then we also looked at who are other folks who would have an interest in this and could be helpful. And I can tell you that in chairing that committee, I made sure that every single one of those meetings were listed as a public notice in the way that we do that with public meetings. They were recorded, and then we had minutes. Every single person who was a stakeholder in the group was invited and encouraged to be at every single meeting. And if they couldn't, we asked them to have a stand-in there. The consultants were sent an email by me identifying the bill, identifying that they were consultants, and identifying when the process was starting. The first meeting in July, that we were going to hold a special meeting in September where we were going to start with them and whatever they wanted to share with the committee, that we would also consider their written testimony, and that they could come to every single meeting. So I just want you to know that I made my very best efforts to make sure that this was an inclusive process, because we wanted to make sure we had all those voices in the room so that we could get all the input, so we could come back to you with the best proposal that we could. And I feel that we've done that. I feel that we've come back to you with a very good proposal about how to start to introduce the idea of some sort of compliance, some sort of making sure when somebody's told that they have to surrender a firearm, that something happens at that point to ensure that that takes place. And we tried to identify what those missing elements were. We tried to make sure, of course, that defendants understood the process and had adequate notice that how it would work, so they could be prepared, to make sure that victims were informed along the way. If somebody didn't surrender a firearm and they were supposed to, that somebody told them that, so they didn't make the same assumption that lots of us make, that the court ordered it, so it must have happened, because we don't want people making that assumption. And making sure that there is a process. So I'll give you an example. When you all originally set this law up, you said that a third party could hold a firearm if, and I can't remember the exact wordings in the statute, but it's just basically the same wording now, as long as it doesn't pose a safety risk to the victim. But there was no process identified to look at that. So nothing happened. There was no process. So when Eric refers to it as a new requirement, I guess I wouldn't really call it a new requirement. I would call it spelling out the process that I think was intended behind what you did initially, but actually making that process clear and transparent to everybody about what would need to happen. Because it's important to keep in mind, while we talked about there's 3 places that firearms can go if somebody is ordered to relinquish them. And again, this only impacts people who have orders against them and are told they have to relinquish firearms. This has nothing to do with people who are hunting and sports people who are just using their firearms in an appropriate way. It's very important to think of those as buckets. And the biggest bucket it usually falls on is law enforcement. Law enforcement is going to do this. You've directed them to perform duties as a law enforcement agent, carry out those duties. This is one of those duties. So even if they don't have the space, even if it's not a particularly great time for them, they're going to do it because that's their job. It does, as I think you identified earlier, lots of things fall on law enforcement to do. That's a big bucket, and it's a safe bucket. But part of what we were trying to do in this bill, go ahead.
I'm just listening to what you're saying, and I do mostly agree 100% with what you're saying. But having been a law enforcement officer and having done this many, many times, and having to take things back to my office, catalog and record all these numbers of firearms, more recently than before. Before, the third-party rule, we relied upon that. And we didn't, it was a process still. It wasn't, we're just going to go, okay, you can't have them anymore. We're going to give them to this person. We found the safe person to give them. It was left up to us because it's on us to make sure they don't get back. So we found the safe person to give them. And I guess I was assuming sort of when you say process, there wasn't. And that's how we were trained.
Well, I think
it wasn't necessarily in writing, but that's how we were trained to do.
And I don't mean to say that law enforcement takes that duty lightly, but I don't think it was ever intended that law enforcement would make the decision. I think we've always wanted those decisions made by judges who can hear from the different parties involved, who can look at a background check, and who can have the party in front of them. So one of the things the judges would probably tell you is that they don't have any authority to order a third party into court. So the defendant has to be the person to bring that person with them if they want that person approved. And I don't want to get too far down the line of third parties because I really do want to go back to the buckets. But you go ahead.
And that was all part of the process as well. It's consulting with the person that owned the firearms. Is this okay with you? Because we didn't want to end up in the middle of something that I didn't want to give to them because I thought they would steal them or sell them or whatever. And this was prior to the NICS anomaly. Okay. But even now, there's many people we have an option to give them to that do not need a NICS transfer, family members, for instance. Just throwing that out there. And that's kind of a loophole that we missed.
Well, in a domestic violence situation, though, I mean, I think you're talking about the background check bill that talked about normal people who are not normal people. That's not the word I want to use. People who don't have any kind of protective order against them. That's a whole different bucket of people. Those are people who may be.
Right. I understand what the NICS check does. But
yeah, they're just selling the
family members that are not required to do a NICS check for me to give it to them.
Yes, because you two are presumably both just lawful citizens with no protection orders against you. If, however, and you've already done this, this is not new to this bill. The bill says that it can only be held by a third party if that's not going to pose risk to someone. Someone has to make that determination first. And I can tell you that no judge wants to be put in a situation where they're asked to make that determination without being able to look to see whether the person who's being proposed is even legally able to hold a firearm.
We're looking for a problem before that. I mean, they already have lawful ownership. We are now taking them away. They would have already been able to give those guns to somebody lawfully and say, here, without a judge.
Yes. Before they had
and it's the mission accomplished. And it's still relying upon the honesty that, like I said before, you can come and take all my guns out of my house. I'm sure you missed one. And if I end up back there or whatever, I mean,
I guess maybe I'm not following your point exactly, but the that you're talking about, as I see it, you're describing a situation where two people are just selling each other a firearm or giving their firearms. And really, the government has a limited role to play in that. They have a role perhaps, and we made a decision as a state that when it was a close family member, we weren't going to require any additional steps to make sure that person was a lawful owner. That was a policy decision you all made, which has nothing to do with the people who have a relief from abuse order against them or an ERPO.
Right, but even if there's a relief from abuse prevention order, something like that, and I am now mandated lawfully to give those up.
Okay.
And the only, right, if you're asking me to give those up, I have to give them up. How are you gonna know I gave them up even, for instance?
Well,
You don't know.
you're right. This, and we talked about this
And that-
before.
and-
We're not necessarily going to deal with the person who is going to lie to law enforcement and say they don't have any guns. We don't address every single scenario, but we do, and I think Major Peterson said this, we are making a step forward. We're making a process better. We need to.
The major's not gonna tell you anything different, he's command staff. I understand it's on the working level, that is, the third party is the most streamlined, safe way to handle all of these firearms.
Okay, I agree with you on the streamlined, but I am going to disagree with you on the safe.
If somebody's
Because I can tell you
That's
that is not, in many states, they have, and we're not debating this now, because I want to be clear that we're talking about this bill, which is not taking away a third party and has nothing to do with that. That was a decision that was made back in 2013 to include that. So whatever you do, this is already exists in Vermont. We didn't take any steps to change that. When I said to you, this doesn't retain any different firearm restrictions, it doesn't. It doesn't change the ability of a third party to hold a firearm. All it does is make sure that it's done in a way where there's some safeguards around it so that we know that, for instance, we're not handing a firearm to someone as a court-ordered person and handing them a firearm and then finding out that they are a prohibited person. That would be bad. And that could happen.
Just for
in your-
conversation purposes here.
Okay.
When we go and we do this and we do the service, the safest time to do it is when they initially find out what's going on. And that's when we're there serving the order. And we can handle it right then and there.
Yes.
And be able to pass those things off, not have a time to wait, to work something out, to find out where they're going, to do the NICS check. If they get sometimes temporaries, they relinquish firearms. I've seen that happen,
Yes.
right? And so when you go, you immediately make some
Yes.
sort of accommodation to make that happen.
Yes.
And
And the
it's
only,
not necessarily law enforcement, it's not necessarily an FFL, and we rely upon that. This is gonna make it one of the strongest in the nation. Not one of the,
no,
it's pretty close.
no, there are states that
I
do
know,
not
I'm
allow
look-
a third party to hold a firearm once a
I know
court
that.
has ordered it. So
I
I,
understand that, but I mean,
Okay.
in totality, we're gonna be,
Madam
I'm
Chair,
just telling you my
I'm
concern.
having a hard time following all of this. I feel
Okay,
like it
sorry.
is back and forth versus just a
Yeah.
question and response.
My concern is really if somebody owns a firearm, I own firearms, they're still my property and I'm supposed to relinquish them. You're relying upon me to relinquish them. And if I can already break the law by not relinquishing them the way that you are asking me to. You follow?
Yeah.
And so I'm already in violation of the order. But yet nobody knows the wiser until it's too late.
So,
Giving up the firearms to a third party at least is a very good way to get things going. And maybe the victim can identify, well, I don't think you have them all or something. I mean, we can't just go in and search the place.
so you're, I'm trying to understand, there's a couple intermixed issues that you're raising here. One is whether the defendant is going to actually give up all the firearms or hide them or whatever. And the other is how expeditious it is to be able to remove those firearms and get them into a third party's hands. So And so law enforcement, even with the temporary RFA, or well, if it's an ERPO, they have to relinquish their firearms. You go out there and it's the first time you meet the person, and that's the opportune time, instead of giving them like directions that you can go through this process to get a third party. We're going to take them right now, and you have Uncle Jed who's going to be able to take them. So is there anything preventing that from happening at this point? But then the court, subsequently needs to essentially approve that Uncle Jed, or we find out, well, actually Uncle Jed is a prohibited person and we need to, in fact, do something different. And is there anything that prevents that initial action to try to get those firearms out of there and to a third party, because the particular law enforcement agency doesn't have storage and there's not an FFL there, right? I'm trying to understand that.
Yes. It
I mean, am I
has to
taking
go.
that kind of in part?
Kind of, yeah, and I mean, if the final, or if the temporary order, for instance, mandates that you take firearms, that's good. It's easier to do, especially if there's a third party willing to take custody. It could be the victim's brother. I don't care who it is, just long as the person is okay with it, who owns them. And in many instances, like in my house, for instance, it's mutual property. I know it is. I mean, we pay for this stuff. So everybody has a vested interest in it. And a lot of homes involved, right? So a third party is good.
Right. So I just wanted to understand that scenario, because otherwise we have this process. And one of the questions I had, which I want you to address, is what about the notice to the individual about third party being one of the options? But let's put that one aside and talk about this first kind of scenario that I can imagine.
So in the scenario that you presented, and Uncle Jed wants to be the person to hold the firearms, they could not be the person to hold the firearms at that stage. The best time, you're absolutely right, the best time for law enforcement to collect the firearm, and that's only in cases where the judge has ordered that a firearm be surrendered. Okay, so there are temporary orders. It's completely a discretionary decision by the judge whether or not that is necessary to provide the level of protection that the judge feels is necessary. If the judge orders that, it cannot go directly to a third party at that moment, because we have to have a process to see whether or not the third party is going to sign an affidavit, understanding that they are creating a legal obligation for themselves and that they could actually be charged with a crime if the person were to get the gun back. There are rules around that, even federal rules, like federally people can be charged if they transfer a gun to someone that they were not supposed to transfer it to. So,
just a follow-up question. Where would the firearms go in that scenario?
they would be held by law enforcement. If law enforcement had a relationship with an FFL because they didn't have their own storage, this bill makes it possible for that law enforcement agency to then store the guns with an FFL just for that period of time before the court has a chance to evaluate the third party, make sure that they are a appropriate person to hold the firearm, and that they are actually legally able to hold the firearm, and that they're willing to do it. Because, grandma might say, sure, I'll do it in that moment, and then look at the obligations and think about, like, what am I going to do when my grandson walks in the door and says, I want my firearm right now? They may decide, look, I don't want to end up getting charged with a crime. I don't feel comfortable doing that. It might be better for grandma to loan her grandson the money to pay a storage fee to the FFL rather than create that disharmony in the family where she has an obligation that she's really not comfortable with. And she feels that she's having a hard time saying that to her grandson. That's just an example. So during that window of the temporary order window, where two things have happened, the defendant has been served with a temporary order, and the order itself says that they have to surrender firearms. The only option at that point is going to be law enforcement and an FFL, because there isn't an opportunity in that short window there to do an evaluation as to whether that third party is someone who can hold the firearm. But they're going to have an opportunity as soon as they have their due process rights. They're going to have the opportunity to decide that they want to do something different. And it could be a third party that could hold the firearm if they're approved. And I wanted to come back to your earlier question, which is how does the defendant know about any of these things? And we created a brochure, well, not really a brochure, it's really a 2-page document that will be attached to all relief from abuse orders and ERPOs once the Family Division Oversight finishes revising it and has it the way that they want it to be. We submitted it to them back in September. This work group, as part of the work we did, we looked at the document that another group that I worked with had created a draft through EPTAP, the Firearms Technical Assistance Project. And this work group went back and looked at that draft and then submitted it to Family Division Oversight. So the idea will be that there will be something attached to this order. So it's not part of this bill because it just was already happening, basically. So there is information in this bill to make sure that defendants get that information when they are, for instance, relinquishing a firearm and the law enforcement agency is holding it and going to transfer it to an FFL, they're going to get the same information about the possibility of having a third party hold the firearm. So they're going to get that information. It's also on the court's website right now and an affidavit form. And I can tell you that nobody's using this process. I mean, they're not using the process because it's not mandated that they do anything right now, as you were pointing out. And so when I asked the court for data about how many third parties they had applications for in the last year and a half, they told me they had one in the last, and it had just been filed in the last week. And so I think it was a result of people talking about this more. So I think you were trying to create a process, but I'm just telling you that process is not being used. The affidavits are on the court's website. There's information on the website about how to do it, and it's not being used.
So
Tom and then
we don't get too far down the road. So grandson has the firearms taken away. Grandma becomes the third party. Grandson goes back to grandma, says, I want my guns, and she gives them to him. What's the crime?
She can be charged with contempt under the statute that you've already passed. So this is nothing new. And there's also federal law that applies to somebody transferring a gun to a prohibited person. So even if she's just handing it back, that's still a transfer to someone. So there's already existing law. It has nothing to do with this bill.
So where would the existing law come into play that relatives can hand guns back and forth to each other as far as ownership goes?
Are you talking about the background check law? Or
No.
are you talking about this law?
To give a firearm to a close relative, there is no background check. You can
If-
give, it's like whether it's Tom and his wife or grandson and his grandmother,
If grandson has a protection order issued against him and he wants his grandmother to hold his firearm, because it's already a very dangerous situation where the court has made a decision that this grandson poses a risk to the petitioner or the plaintiff, then grandma is going to have a background check because we don't want the court authorizing and handing guns or anybody handing guns to a third party in that situation that we've already deemed to be dangerous. We already know that there's abuse going on. The court has found abuse and that there's a danger of further abuse. So in that situation, even if you're giving the firearm to a family member, they're going to have a background check.
and one more. You as a state's attorney, deputy state's attorney, right?
I'm actually assistant attorney general, but that's okay.
That's what
Same kind of stuff.
okay, right. Are you charging an 85-year-old grandmother in this case?
Am I charging grandma?
Vermont isn't charging an 85-year-old grandmother in this case.
Well, there's always discretion there's always discretion. I don't let you talk about being a deputy state's attorney. There's always discretion involved in who gets charged. But the point of it is that there is criminal liability for doing that.
Oh, no, I
So
realize that.
contempt.
Welcome
It's a
to
civil.
Vermont. It's not getting charged.
It's a civil contempt, actually. So the court could find grandma in contempt civilly and fine her as well. But I'm not saying it's going
understand what
to.
you're saying. I know Vermont well enough.
The main thing we,
This case.
honestly, that whole idea that you can be charged with a crime or you can be, held in contempt. I mean, honestly, I don't want to sound flip about this, but who cares? The issue is whether the person has access to the gun. If they get that gun and they harm someone, who's going to care about whether or not we can file a charge against someone? The whole idea, what
The
we're,
law is supposed to be the thing that's going to stop the person from getting it back.
yeah, laws do that. But some people are inhibited by the idea of a law. But what we're trying to do with this is to create a process where that person doesn't have access to firearms when they're not supposed to. Protect them from themselves, from doing something that they 6 months from now probably wouldn't even consider doing. So you remove the firearm and you reduce the lethality of that situation. And it applies with ERPOs too. I just was in an ERPO training yesterday for social workers listening in. And they talked about a multi-state study where for every ERPO issued, they estimate, for every 17 to 20 ERPOs issued, one life is saved. And that's because most ERPOs are issued in situations involving suicide.
One more
So this is a preventive method. It's a preventive method to take the firearm and then return it to the person when there's not such a volatile situation going on.
Not in here that you wanted in here.
Oh, I'm not even going to go down that path because everything was a compromise. I mean, we talked about these things and we came up with a consensus of things that were important steps forward. I mean, I think when Major Peterson said, "Is this everything?" Well, of course not, but it's a step forward. And
No, I'm not talking about anybody else.
yeah,
Is there one specific thing that you wanted in here that's not in here?
no, I mean, I'm speaking for the group and we spent a lot of time on this and had very long discussions about, and I think Representative Rachelson mentioned this, like when victim notification, when you're talking about reasonable efforts, I mean, could we require more things? But we have to think about law enforcement has a lot on their plate already. And if somebody is, homeless or moving around a lot, they might be really hard to reach. And so we wanted to be careful about it's a balance, right? You're doing the best you can.
What's the homeless connection?
Someone who has a relief from abuse order, they're the plaintiff. And let's say that they are currently unhoused and they might have a phone, they might not, they might be very difficult for a law enforcement agent to track down to say, hey, guess what? The firearms that were taken from your ex-partner when you got that relief from abuse order, they're going to be returned in the next day or two. So that might be very hard for them to find that person. We want them to make a reasonable effort, but we understand that saying that they must be informed is perhaps, just a burden that can't be met with existing resources. So that's just an example, but it's better that we're making a reasonable effort because right now there's nothing that requires them to be notified at all.
So overall, how does a third party relieve law enforcement from any duties when the firearms would be relinquished to them first anyway? Other than the actual physical storage. They're gonna have to I believe this, if they take the firearms in, they're still gonna have to do all the paperwork and documentation. Same amount of work they would do as if they were storing, and they're just not storing. And then what, if they did go to a third party, would all that paperwork and documentation have to be done again?
There will be a process to make sure that if a third party indicates that they're willing to hold a firearm, that they're actually holding it. So, I mean, anybody can say anything, right? So,
but law enforcement is in between the court and the third party.
yeah.
They're still doing the same amount of work to document. The only thing they're not doing, well, they may even have to store them for a few days, if the court doesn't make the decision right on.
Yeah, I mean, law enforcement was part of this conversation, and I think everybody.
I'm not saying I agree or disagree.
Yeah, right. I mean, I think everybody was thinking what's the least burdensome thing that we can do that still provides some measure of safety. Because right now, we don't have that. I mean, if you were to just say anybody can hold your firearm, what happens 2 minutes after the law enforcement officer leaves? And that's not really accomplishing anything.
Officer, Representative Oliver. I remember it seems to think the system they have now for third party is pretty efficient, safe. And I don't know, is it there?
It sounds like he personally did it in a way that was very responsible, but there was nothing in the law that required them to do that. I mean, but it's.
No, and I
not a
realize
decision
that we were talking about things being burdensome and that type of thing. And I think it was said the system being less burdensome, and me, that sounds like would be the less burdensome way to go is from wherever the firearms are, right straight to a third party. That's.
And the only difference in here is that we're making sure it's something that the court approves. So we're actually creating.
No, actually, then you're putting the work on law enforcement to do all the documentation also. And possible storage for a period of time, so there's a little bit more than just that.
And that's really the temporary.
No, I know that. I
Yeah,
know that.
yeah. No,
It
it's
seems
just- I
like
just wanted to make sure I
almost
understood.
unnecessary stuff, though.
Yeah, I guess I can't think of any alternative that would both be less burdensome and would provide any level of any level of compliance process. So, I mean, we've made it as minimal as it can possibly be and still have some sort of process to it, if that makes sense.
Another question that had come up earlier is immunity for third parties. Maybe even to partial immunity somehow. That some of the responsibility would be on the firearms owner, it seems like, that they are picking them. But on some level, it seems like they should have at least partial immunity. I don't even know what at this point. But you folks decided on no immunity for third parties.
Well, I mean, I guess I think but so far that the laws can go in protecting people from making bad decisions, right? I mean, if I loan you, we talked about this before too, if I loan you my lawnmower and then you go off and sell it, I might have some sort of civil remedy that I can pursue. I can prove it was my lawnmower, but I mean, that's just, that's not really something that the law would normally step in and decide that, like, you know, what should happen in that situation. I'm saying it's my lawnmower. You're saying, oh, she left it on the curb and it was abandoned and, you know, I took it. I mean, we don't usually get involved in that. So the third parties are generally going to be people that the defendant knows and trusts and has some sort of relationship with.
No, I
Right.
realize that. It just seems like there should be some. I don't even know what, I mean, if the third party doesn't own the house and they get stolen from the house, and the third party member responsible for that?
That's going to be up to the two of them. I mean, if they want to create paperwork and a contract between them, they can do that. But that's not anything that we would get involved with.
So.
I mean, they do have a contract with the court.
Right.
And they have an affidavit that the court, that they've signed that says that they're not going to give the person the guns back. But it doesn't say what they're going to do if those guns are stolen. They would have to pursue their civil remedies as the owner of the guns.
Proof of insurance, that the firearms would be covered as far as insurance goes, if they're gonna be stored in their home?
I don't know.
About with an FFL, if an FFL stores them.
Well, yeah, FFLs have all of that. The person would be able to, if the FFL burnt down, then I'm sure that they have a mechanism for reimbursing people who they're holding their property for. But that wouldn't, I mean, with a third party, that would just be between those two parties. I mean, otherwise you're creating a lot of regulation to be a third party that isn't
Yeah, that almost seems like and I don't disagree with third parties. But it almost seems like they need to hold some responsibility. Where it appears they really don't have a lot at all, other than to store them, not give them back.
And that's really where our interest ends, right? Because all we're worried about is reducing the legality.
To me, that's not where our interest should end, because we're writing a law that says this is the way it's gotta happen. It seems like that third party somehow should have some responsibility, or at least some kind of insurance or whatever, that there's another part of the protection, because there is if they mishandle these firearms, if they're reckless with the firearms, they're responsible for the damage done to them.
But potentially there could be a civil action between the two parties, right? I mean, if I damage your property, then you can pursue some sort of civil remedy for that. Sorry, I'm not answering all of your questions.
Well, pick your third party well, or give the third party some coverage in the bill.
Yeah, I mean, I think when you think about third parties, you should be thinking about a family member, a trusted friend. That's the kind of person that would
A family member that you can just give the guns to now, without having to go through all the paper.
Well, there's supposed to be a determination that doesn't place the victim at more risk. And that is in your existing law.
No.
So,
Okay.
no questions of
I'm
Tom and then Ian.
Clearly, we're on a little bit of a philosophical difference, but I don't think we're that far apart. Vermont's firearm transfer rules are stricter than the federal government. So
Yes, the
so as
background
long as
check.
we
Yeah.
abide by Vermont's transfer rules, we're okay. And I'm not saying third party is gonna be my answer every time. I know there's gonna be times we're gonna have to do other scenarios. Doesn't make sense to me when I go to a house. The defendant's gonna have to leave, the survivor victim is gonna probably have the house. And that's where the safe is, and that's where the firearms are, and if they're fine with it, to keep them.
Okay, but
Or
let me give you an example though. Like, so
Go
they're
into what
gonna,
if. We've
how
got-
are you gonna find out if
Let Tom finish before.
Well, yeah. But if they're willing to take custody of the firearms in the house, they may want to have a firearm. I don't know. Why wouldn't that be an acceptable solution?
because
Or give them to another family member, a trusted family member, even, it doesn't matter what side, but I suppose it would make more sense to the survivor side or the victim side to hold on to them without having to do the NICS check. The ownership is still the ownership. We haven't violated any laws. And if someone gives them a firearm or they take the firearm, they're breaking the law, the order. The defendant would be breaking the order. And I would encourage a NICS check before the return, no matter where they are. That makes the most sense. But doing NICS checks to where they go, I don't think it's really a thing we need to do if it's lawful to already do that. The person's the lawful owner or transferee.
but they
Just-
might not be a safe option for the person. And the background check is one way that the court can look to see whether or not they're
Who may
actually
not be a safe option.
the family member. There's no way, I mean, just because you
The
think that,
NICS check's not gonna tell you if they're,
it'll
unless
tell
they're
you-
disqualified.
yes,
It will
that's what
only
it'll tell you.
if they're disqualified.
Yes, that's what I'm
Nothing-
getting at.
Nothing says I have to do that if I want to give them a gun. Here, gift. And
Um,
that's what I'm doing essentially. And you hold on to it, you give it to me back. We do it all the time.
Yeah, and that's totally fine unless there's a finding that the person has engaged in abuse, and then there's heightened interest in making sure that if you give the gun to
Then why
someone.
isn't it required when I give one to a family member already?
So there's it's a different status as well. You
Well,
are,
it's going to someone who's not accused of anything, for one.
but the status is that you're transferring ownership, and that's when you can transfer ownership or gift a firearm to family member. But this
You
is a
can loan
different,
as well.
what's that?
You can loan as well.
Yeah, but this is a different kind of scenario. So I think we understand the difference between what you're saying, and I think that Carolyn has fully explained the reasoning behind this. We will have to have some more discussion about it later, but I think let's move on though, because we're going to be done in 6 minutes.
Oh, gosh.
Ian has a question.
I haven't even answered all the
I was
questions.
Well, we're going to have you come back, I think. And we can continue the discussion within the committee. But Ian,
Yeah, my only question is, because I think I take Tom's point really seriously about you've got officers showing up to a scene of domestic violence, or they are serving a protective order. And like, that's the moment where taking the guns is like probably the safest and the most efficient, and for lots of reasons, the right thing. In the bill, for the statewide model policy 1 and 2 of like the things that the statewide model policy would be tasked for creating a policy for would be removal of firearms from scenes of domestic violence and removal of firearms from when serving protective orders. So do I kind of understand that to mean that this model policy would establish sort of 4 departments across the state to basically be considering and probably trying to do that seizure during those times, despite the fact that they would not have access to a third party immediately to give the guns to, that they would have to wait till we got to later in the court process where a third party was approved?
I think if I understand your question.
It's a long
yes.
question.
Yes. I mean, yes, it's making sure that law enforcement understands how to proceed when they're serving an order,
Yeah,
that they don't just hand the order and walk away.
yeah,
That if the order requires that the person surrender firearms, that they explain that to the person and they ask for those firearms and they say, the order requires that you relinquish your firearms to me. And, allowing the officer to have a conversation.
Yeah.
And officers would be trained in how to do that in a way that is not confrontational and is very like warm, making the person aware that, you're going to get a chance to have a hearing, you're going to get a chance to explain your side. You can have other people hold your firearm if you would like that down the road, all those kinds of things. But yeah, that would be part of their model policy, how to have those conversations with people and make sure they're aware of their rights and their responsibilities.
And so when you guys were talking about the model policy in the group, was there discussion around a scenario where departments didn't feel like, or representatives from departments didn't feel like they had the capacity to seize the firearms at that time, and that they were basically leaving them there for then, I guess, the individual to forfeit on their own? I guess I'm seeing that issue. I think it's a very real one, that basically like the moment they're served with a temporary RFA, they actually should have possession of firearms. And if they are charged with a crime of domestic violence and they have a condition of release not to have firearms, then they would be in violation of those conditions. So like making it so that the moment that thing is in effect, they are not in possession of firearms seems to be really important. And so I guess what I'm just trying to understand is, are we establishing in here by policy and also procedure that law enforcement, being the first people who are engaging, are going to be able to get those firearms for the very immediate and hopefully very temporary time before we have the hearings, so that you can establish a third party? That's what I want to understand from this bill, if you feel like it's doing that.
I think that it will require law enforcement to make their best efforts to do that. There are going to be situations where the defendant is not in the place where the firearms are, so it might not be possible. But they will be instructed in scenarios. If the person says, my brother has my gun, well, then the law enforcement officer should be asking about, who's your brother and how can I get a hold of them?
Yeah.
So, And so, I mean, I feel like it's a step forward, and then the officers will have to decide if they, for instance, there's also a crime going on and they have information that there's firearms in the house, maybe with a criminal case too, they can apply for a search warrant if they needed to. So maybe they can apply for a search warrant and not use it unless the person doesn't give them the firearms that they know to be there. So I think it will require some work on law enforcement's part to do their very best to obtain firearms in that scenario. Being mindful of your point, we don't have any kind of registry. We don't really know where we're relying on what information law enforcement is told.
Yeah.
So they're just doing their very best reasonable efforts.
Okay, thank you.
Does that answer it?
Yeah, no, I think it's really at the crux of a lot of, like, it's at this moment that's very important.
A common tactic before transfer was when we'd serve something and the person had control of them and took them away or did whatever we had to do. That's when we had the person, let's give her the guns, okay?
Yeah.
And that's what happened. It disappeared.
So we're gonna have you back on Friday, I think, because we're going to, my understanding latest is we're going to be on the floor for a little bit and then we'll be off the floor because it's towards the end of the biennium and we'll be coming back in the afternoon on Friday to the floor to see if the Senate has sent us anything over. That's kind of where we are in the biennium. So we will have some time on Friday morning to continue this testimony, and we need to hear from Charlie as well. And we need to have some, I'm sure, robust committee discussion as well. But just tomorrow, real quickly, and you don't have to sit there anymore if you want. SS 193, there was I guess I can call it a negotiation among the committee chairs, and we have a version of the bill that at least has the committee chairs on board with it. There are things I don't like about it, but that's the world compromise. And the main thing is we want to get this out and get it over to the Senate so that we can have a conference committee on 193. And so we will see that bill tomorrow, and I'm scheduling to vote for Thursday. And Thursday we'll also look at the miscellaneous bill, the amendments that we're expecting on the miscellaneous bill. So we're adjourned until tomorrow at 9. Are you off live?